So today's guest is Sir Max Hill, KC. He is a former Director of Public Prosecutions and now is Senior Counsel at King and Spalding. Let's listen to him talk about the justice system from 40 years of experience. So let's jump in. Wow, so Max Hill, I'm guessing I can just call you Max.
Of course.
Thanks. Amazing that, we've got so much going on in the justice system, lots of talk about it being broken and changes coming along. And I thought you would be an amazing person to talk to. And we did have a brief chat about some of those things, and your ideas and some of your positioning I found really fascinating and heartwarming. So why don't we begin by you just telling us a little bit about yourself?
Sure. Well, thanks for having me on, Maria. It's good to spend some time with you. So my name's Max Hill. I'm a barrister, qualified almost 40 years ago now, 39 years this year. I spent 30 years in court doing all sorts of things, but that included both defending in a lot of criminal cases and prosecuting in a lot of criminal cases. And then for 20 of those years, I moved into terrorism casework, on which I prosecuted. And then two things happened really after that. Firstly, I became the UK independent reviewer of terrorism legislation at the beginning of 2017, and my job was to provide reports to government, which then went to Parliament. They're publicly accessible. And I was writing those reports in the immediate aftermath of the terrorism attacks that we had, starting with Westminster Bridge in February 2017, then, of course, including the Manchester Arena concert, the London Bridge attack, and then two others. It was a very busy and tragic year. And then at the end of 2018, I was appointed Director of Public Prosecutions. So that meant I was the head of the Crown Prosecution Service for England and Wales. And that is a 5-year term. So it was 1st of November 2018 to the end of October 2023, after which I had a rest for 3 months. And now I work for an American law firm in London called King and Spalding. But I have what lawyers call a dual practicing certificate. So I do some outside legal consultancy work through the chambers that I used to head in London. It's called Red Lion Chambers. And I'm still, in the language of lawyers, have my name on the board there. So I try to do an interesting mixture of things. That's me.
That's really kind of huge in many ways. And I think as you were speaking, what came up for me is some of the burden of responsibility that you carry, especially as when you were Director of Public Prosecutions, but also talking about prosecuting terrorism and some of the tragic acts that have happened that have affected many people. I wonder if you might speak to that burden of responsibility.
Yeah, I mean, I would put it more as good fortune, being in the right place at the right time, and being given the opportunity to just be part of the team on some of what, I think we can call the great criminal cases. And one of the phrases I very often use is that all terrorists are criminals, but not all criminals are terrorists. And a lot of the tools that we use to deal with modern terrorism are the same in relation to general crime. We use Acts of Parliament, we use criminal offences, sometimes we use specialised terrorism related offences. And I was lucky to be the junior member of the legal team that prosecuted what we can now call the last IRA case. It was actually the Real IRA who conducted a campaign in London and elsewhere in 2001. And I was on the prosecution team for that. And then thinking that that would be the only terrorism case I'd ever see across my career, no sooner had we finished that than we saw the first Al-Qaeda case, which was in 2003 in London. That was followed in 2005 by the July bombings, 7/7, everyone's familiar with, and then a second bombing on the 21st of July. And that then was followed by the so-called Islamic State era. And I was on board, first as a member of the team and then leading the legal team to do those cases. Of course, they were all huge responsibility, but they were also a big team effort. Nothing that I was doing was unsupported by the police, particularly by counterterrorism policing. I was just the lucky person who became, if you like, the spokesman, the speaking voice in court, trying to land the evidence that had been gathered. But yes, it was an extraordinary time, and that was then capped out by the terrorism reviewer role. Although when I did that, I think I became known for basically saying, we got enough law here. We don't necessarily need more of it. And what I meant by that is, in many of the most serious terrorism cases, including the July 2005 bombings, what I was using was the good old-fashioned common law offences of murder, conspiracy to murder, as opposed to some special 21st century terrorism offence. One of the features of this area of law and other areas is that we've had so many new acts of parliament, so many new offences created. Often I think we can deal with it with simpler tools that have been around for a long period of time.
Yeah, that's really, for people like myself who are not in your world, and hearing you speak, I guess that a big part of your role, or perhaps the whole of your role, is literally looking at the law and taking the things that happen in life, and some very tragic, and applying the law to those. Is that a good way of thinking about it?
Yeah, absolutely. And I think that the point that we're both really making here is that the law intervenes, the law gets involved when somebody does something that crosses a line and that represents a criminal offence. There's a huge amount of activity that we all get involved with as citizens which doesn't cross that line. And one of the things that lawyers are doing, and particularly prosecutors are doing, is looking for where the line is crossed. And in doing that, of course, they're looking at what in America you'd call the perpetrator, what we call the suspect here, the person you're considering charging. And what you're trying to decide is what this person has done, does it require a formal court process or not? And there are many cases in which, even though you've got a certain amount of evidence, it doesn't follow that you have to bring that person into the criminal justice system. So there is that dividing line, which you're always looking to see whether a person has crossed the line or not. But I emphasize that even where that line is crossed, it's not lawyers who find people guilty in court, it's judges and juries. And that is their job. It's not the job of the prosecutor to do anything more than say, we've got enough evidence here, we've got enough material, we think a court should consider it.
Yeah, that's a good and interesting point, that it's not the job of the lawyer, it's the job of the jury and the judge, and that's why you have a prosecution and a defence. I mean, I think where I went as you were speaking was, we've been talking about really big stuff like, terrorism and bombs going off. And I was thinking about some of the sort of stuff I do working with people who've, created acts of violence. And the way I talk about it, and I'm just interested in your opinion, is, often someone will be very angry, now they're going to be on trial and obviously they want to defend themselves, or, they've been sent a non-molestation order or a restraining order and they'll be very angry. And the way I often talk to people is I say, we live in a society that creates certain boundaries, and what's happening is you're bouncing up against one of those boundaries and society is sending you a message. And so you have quite a lot of choice at this point about what you want to do, about how far you want to take it. Now, you talked about the line, and I'm saying whether you want to cross that line, and then society will stop you in your tracks. And that's kind of the way I talk about it. I'm interested in your take on that.
I think that's a very good way of looking at it, Maria. And the way I put it is that line is actually created, if you want to look at it this way, by the whole of our society, not by us as individuals making laws which set out the line, but by electing people to Parliament, and Parliament then draws the line. And anything that a police officer or a prosecutor does is governed by where Parliament has indicated that a certain kind of conduct is going to be marked as criminal. Now, where it isn't, then you can do it. And the way lawyers in England often talk about our system of legal precedent, what that means is that actually you're entitled to do anything you like unless Parliament has come along, or we could say the common law, or Parliament has come along and said, actually, that is conduct which is not acceptable to society, so therefore you can't do that any longer. So it's permissive, except where there's something that has been marked as criminal. Now, you mentioned people who are angry, people who are violent. For me, if you are personally violent to another person, or you threaten violence to another person, put someone in fear of violence, that is almost always criminal conduct. And I'll give you an example from when I was Director of Public Prosecutions. We had a system, still have it, of what are called conditional cautions. And that meant that any of the police forces, we have 43 of them across England and Wales, could come to me and say, we think that we can deal with some people instead of putting them through the court process by giving them a conditional caution. Can we agree with you as the DPP a list of offences, a list of types of conduct, which although we could prosecute it, we think actually everyone would be better served by finding a way of marking that with what's called a caution, setting conditions to that, and saying to the individual, if you stop acting in that way, and we're sure you're not going to do it again, you won't face a formal appearance in court. But if you do, you will. And that those lists would come to me. I think there were 8 police forces I remember coming to me quite early in my time for me to assess and then sign off these conditional caution schemes. I wouldn't sign them if it involved, for example, knife crime or robbery on the street, or what I said before, violence to the person. But I would sign them where you might be looking at someone who was committing shoplifting, even on a habitual basis. But there was a background to that. There was a kind of reason for that through deprivation, through drug use, etc., where with the right work, with the right input, some of those police-led schemes were really effective in showing people another course. And instead of them coming back into court every month or every 2 months and getting a slightly longer sentence or a slightly heavier fine and going out and committing a crime again, we saw that that stopped. And, in legal language, recidivism considerably reduced. So the way you police that line with a small p can be really important in looking at how to deal with some elements of, what you might call crime wave. And that out of court possibility, the possibility of an out of court disposal, I think is really important, particularly at the moment where we've got a criminal justice system that is in paralysis because there's so many cases waiting to be heard. I emphasized again, though, this is not about saying to a violent individual, we're too busy to take you to court, let's not bother. It is about saying in other instances where there's 2 ways of looking at it, and you don't represent a risk to other people, can we find a way of dealing with you? We may go on to discuss how particularly relevant that is, in my view, to young people who, if they're criminalized by the age of 14, 15, or 16, we know their life chances are going to be dramatically impacted. It does not mean that you never lock up a teenager. There are times when you should, and you really must do that. But in other instances, that sort of gateway to the criminal justice system, if you guard it very carefully, can turn people away from crime at a very early stage in their lives, and we're all better off if that happens.
Yeah, so you've done something. There could be a way of dealing with it. It takes them to the precipice, and then they get a chance to look over and see where they could be going, and a chance to turn back. But I suppose because I work very close to the ground, the issue for me with that is then there has to be services around to support people, because if the services aren't there, as you said, if people commit crimes and there's deprivation or addiction or some other sort of traumatic history in their life, then we've got to be able to I mean, that's out of your league, but it would be nice for you to know that those services existed and could be relied upon. And then we have a much better chance of turning people away from repetitive crime.
Absolutely right. And, two quick points on that. I'm very proud to be the chair of the Board of Trustees for the Drive Forward Foundation. And we work right across Greater London, and we have plans to expand beyond London and have done for 15 years with care experienced young people. So teenagers who are coming out of sometimes foster homes, but very often care homes, with none of the family or parental support that, most of us enjoy as I start to life. And they are exactly the young people who can fall prey to crime gangs, who can find themselves criminalized and even serving terms of detention as very young people. Their life chances are damaged twice over. That their care experience and they don't have parents to look after them, and then they have this tag of being a youth criminal. So it's really important in those cases that while you can't say it's carte blanche, do what you like. We're not going to charge you because you're care experienced. But in many instances, if you find a better way of dealing with that, care experienced people are just as brilliant and able to make a contribution to life and earn a living and do fantastic things as other kids who have privileges in their background. So they need to be nurtured rather than just punished from day one. But the point you're making is absolutely right. In order to be constructive and to try to turn people away from being sucked into the criminal justice system, you have to have a mechanism. You can't just say, we're not charging you this time, carry on. You need to say, here are the support services to make sure that you're going to go down the right path. If we were in Scandinavia, Maria, we'd be looking at what's called the Barnahus model, which is, if you want to look at it, it's a kind of detention facility, but it's not a prison. But even for the most serious crimes, they have a way of dealing with and investing in young people, which is surrounded by what we would call social services and support, mental, physical, and otherwise, which allows young lives to be encouraged and be more productive. What we need in this country is something like that. We need greater investment on that borderline between going to court and being constructive, particularly with young lives. And then we would find that not only are we being more constructive, but there'd be less cost to the criminal justice system, fewer cases clogging up our courts, and it would be more productive all round. And I think that's one of the things that have been called for in recent reports. I was a commissioner on the Times Crime and Justice Commission last year, and we looked at that and we looked at trying to turn young people away from being sucked into crime. But that goes hand in hand with investment in those young people and the services we need to put around them. That has to come first, and then we could actually move the dial. We're not going to stop all crime, nor are we ever going to say that serious crime will just be parked and not dealt with. But there will be cases where we can find a better way.
Yeah, yeah. I mean, your disclosure about being on the board of trustees of a charity for care experienced people just really moved me, and actually is very much of the moment for me, because we just interviewed a lady called Kerry who runs a charity called Truly Seen, Truly Heard, who's also care experienced, and she talked a lot about her life and what she went through. But one of the things that really struck me is when you leave care and they put you in your bed sit and they give you a little bit of money to get you started, and then you have no family to fall back on. I mean, you know, who are you going to call? And so, and that's at that moment that really, poor influences can just walk into your life.
Yeah, and to use a phrase, it just isn't a level playing field. And that plays out in so many ways. So when a young person who comes out of care is put on universal credit on the benefit system, and they're given the same as anybody else, I would argue that is not enough in their cases. If you give to a young person who has a family around them a level of benefit, you can't say that a care experienced person who doesn't have that family, doesn't have that support unit, should get the same. They need more. So we would argue, and we have young people that have formed a policy forum within Drive Forward, and this is coming from them direct, who've said that to help the next generation of young people, we need to make a differentiation here. We should be providing higher levels of benefit to people who come from a disadvantaged background like that in order to give them the same chance in life that a child with parents would have. And that can be quite a hard argument, but that is what leveling the playing field would really take. And it would have a huge difference. I got involved in the foundation because I was invited to an event in Parliament when I was still the DPP, and we were talking about criminalization of very young people. And I went along with the guidance that we have for the Crown Prosecution Service on the careful steps that a prosecutor should take before making that decision to charge a care experienced young person or any other young person. There has to be a really intense focus on this big question. This young person's done something wrong. Do they need to go to court? Or can we, in the language of lawyers, divert that into an out of court disposal? And once I'd seen how Drive Forward were thinking about this, looking at this in real detail, it was a very easy decision when they asked me for me to say, once I've finished being DPP, I want to go on this journey with you. And that's why I chair the foundation. And it's been a real eye opener, but I haven't regretted it. And my 3-year term as chair has been richly rewarding.
That is something else. I'd love to know more about this. I'd love to talk to you more about this outside of this podcast that we're doing. And we've moved on to this subject of looking at whether someone actually needs to go to court, whether they need to be criminalised, and as you said, really importantly, it's not about we're too busy, so we're going to park it. It's about how do we create less criminals in the first place through support, through things like conditional caution. And of course, that brings us on to that the courts are clogged up. And one of the ideas is to reduce the number of cases that go in front of a jury, which has created quite a hoo-ha. And we had an interesting conversation about that. And I'm really interested in you putting out the rationale for it and what it really looks like in real terms. And then moving back to the answer is have less people going to court in the first place. And I'd love you to sort of take us on that journey.
Sure, and I have mixed feelings about this, Maria, because as the DPP, I had, if you like, overall responsibility for the entire output of the Crown Prosecution Service. And a lot of people don't know, but the CPS brings 400,000 cases to court every year, from the smallest to the largest. And of that 400,000, actually, it's a very small number already that goes to the Crown Court, which is where you find a jury, as opposed to the Magistrates Court, where you don't. But a headline statistic that came out of the back of COVID, which obviously was kind of nobody's fault, but meant that everything moved very slowly, was that cases awaiting a jury trial in the Crown Court went above 10,000. So the vast majority are dealt with in the Magistrates Court already without a jury. But you've got 10,000 significant cases. These are the rapes, the murders, the terrorism cases, the serious dishonesty and violence cases, which have to have, if you like, a trial in front of a senior trial court. And for that to go above 10,000 was a watershed in the system. So learning from that experience, I absolutely accept that we need to do something to move the dial. We need to introduce greater efficiency in the criminal justice system. And we should be capable of looking sensibly at how we make that decision between holding a case in, if you like, a judge-only court, justices of the peace, or what they call district judges, professional magistrates, or saying this goes to judge and jury. And Sir Brian Leveson, very senior judge, has written 2 reports about this. And in his first report, he's talked about structural change, so whether it's jury or not. And in his second report, he's talked about greater efficiency. What's important is that you don't look at those separately, you look at them together. I thought that's what he intended by his reports. But when it comes to the structural change, I think there is a sensible discussion about what, again, in lawyers' language, I would call reclassification of offences. So those cases which at the moment they're called either way offences in legal language. That means it can be dealt with in a magistrate's court, but if the defendant chooses, they're entitled to have trial by judge and jury. Some of those offences which are in the queue in the Crown Court are at the very bottom end of seriousness for the Crown Court. And I think that there is a mechanism, there should be a mechanism of looking again at reclassifying those offences into what are called summary only. So they'll be dealt with in the magistrate's court. And I don't think that should be enormously contentious. However, when it comes to removing the right to trial by jury, in every case in which a person might receive a sentence of up to 3 years, which is the government's proposal, I have a problem with that. And I have a problem with that wholesale removal of the possibility of trial by jury. What's happened is that we've had the King's Speech very recently. We now have what's called the Court Modernization Bill, and that is where the government have put its proposals, which are not actually the Leveson proposals. They're a variation on that. And that will now have to work its way through Parliament. I think it's going to be difficult, and I think it's going to be challenging for the government to force through a blanket provision which removes the right to trial by jury from so many cases. And there are some specific examples which I fundamentally disagree with. For example, saying that in any case of serious or complex fraud, it should be possible for a judge to try that on their own. I disagree with that. And I disagree with anyone who argues that a jury, ordinary people like us, is not capable of understanding fraud. Of course they are. It's down to the lawyers to explain it in terms that are accessible to everybody. So there are some proposals that I disagree with. But I do come back to the initial premise here that we have a system that is delaying justice for so long that that is the same thing as denying justice. And if you have a criminal justice system that is not achieving outcomes at all, well, you've got to do something to change it. The legal profession, of course, would say more money, more investment. The government has to come up with more money to keep the courts open and to allow us to deal with all this volume. I support the lawyers in that, but I think it's not as simple as that. And there are some changes that we could and should make to just drive greater efficiency. And I spent a long time focusing on that, for example, in rape and serious sexual violence, where I could see that we weren't doing enough. We weren't doing well 5, 6 years ago. A tiny percentage of these cases were reaching the courts, and victims of rape and other horrible sexual offences were having to wait years before they got a chance to come to court. We need to speed that up, and some element of change of structure, this reclassification of offences point I was making, and certainly greater efficiency measures will deliver that sort of positive benefit. And that is what we should be trying to do.
So there are a number of things that could be done. I heard you say that there are parts of this bill that you disagree with, and there are some things that actually procedurally won't make a huge amount of difference either way to leave in the magistrates' court. And I still just would like to come back to, I think actually where I want to go is thinking about when what did I hear you say? Delayed justice could also be denied justice. And I'm thinking about all the people on remand, because isn't it something like 20% of the prison population is on remand? It's a huge number of people. And I know that we don't put people on remand unless we're fairly sure they're going to come out with a conviction. And there's not much being done for those people. I mean, I've been talking to a couple of governors at remand prisons about what we might do with remand prisoners, because there's very little for them. And what an amazing opportunity to work with a few people, because in the time from when the crime happened to, waiting years for a trial, there's a huge amount we can do to change to change their lives and to change their thinking and to change their outcomes.
It's absolutely right that we have to take a balanced approach to this. And you are right to say that where we focus on the victims of rape and getting their story before the court sooner, that also applies to people who are alleged to have committed a rape, who are waiting in custody to demonstrate their innocence. And, as we know, in any criminal justice system, there will be cases which are what the lawyers call a true bill. So the offence has been committed, and once the evidence has been heard, a jury's in no reasonable doubt, the verdict is guilty. But there will also be cases in any category you care to name where the evidence won't be so persuasive. And thinking about exactly what you've said, Maria, where somebody has been in remand, on a prison wing on remand for months or even years, only to be acquitted, you've got to ask yourself, well, how is the system failing if that's what happens? Now, I've been on prison visits, and including with the Chief Inspector of Prisons, Peter Clark. I specifically asked him, Peter, would you mind if I come on a prison visit with you? Because I think if you're a prosecutor, you need to know the consequences of conviction. You need to see what it's like in prison. I think all judges need to have, a better awareness of what it means to be imprisoned. Now, we do know that the regime, the conditions on remand are slightly better than for those who are convicted. They're usually held in slightly different circumstances with slightly greater privileges, but you're still locking someone up. You're cutting them away from their ordinary life. And we need to do that. And there are strict legal tests that the courts apply under the Bail Act, looking at the risk that a person may represent. But if you've got someone who is on remand for so long that they've already served as long as any judge could give them on the trial date, and then they're acquitted, well, that's just wrong. So it's absolutely in the interest of people who are charged, it's the interest of defendants to speed up the system. And so that is one of the things that I think bears on everybody's mind here. We're not sort of in a very clean space where we can discuss this amount of money or that efficiency measure. We are dealing with heavily affected lives, whether you're talking about what many people call complainants, but I'm going to call victims of crime, or people who are alleged to have committed crime. Their lives are all brought to a halt until the system sorts it out and you get to that day of trial. And where that is so far off that victims can't stand it any longer and are perfectly entitled to say, I need to get on with my life. I can't wait for another 2 years. And where defendants are in custody for 18 months, where even if they were convicted, they probably wouldn't get more than 15 months. That isn't right either. So I think the Brian Levison reports, which I mentioned, are absolutely needed. The question is to try and pick out of that the sorts of measures that will make a difference, as opposed to those that might be symbolic but aren't going to make much difference to the time and cost of legal proceedings. That is where the argument is going to lie. And I think that the Court Modernization Bill, as announced in the King's speech, creates some proposals that I have real difficulty with, others that I think let's get on with it as soon as possible. And I hope that the arguments will rage and we can reach a point of some kind of agreement in the interest of balancing the system and supporting everybody who gets involved in it.
So yeah, there are many things that could be done, and I mean overall, as you're speaking, and you go into this world of criminal justice, and it's got all its jargon. So if you're just Joe Blogs and you're being pushed through this conveyor belt that may slow down and grind to a halt, and uncertainty for victims and for anybody, uncertainty is one of the worst positions, isn't it, to be in life. How do we I'd say let's go to young people. So my view would be let's take young people and let's steer them away from this in the first place. I mean, you talked about conditional cautions, and I'm saying maybe even one step before that. What's the kind of education that we need? What's the kind of support that we need what levers could we pull? How could laws change so that we actually conspire to keep people away from that line? That there's a nice big sort of moat just before the line, and we say, don't jump in the moat.
I think that's a very good challenge. And my response to that is that if you think about it, we have a system of government which is not very joined up. A phrase you could use is it's in a number of silos. So we have the Home Office that's responsible for policing, the Crown Prosecution Service and the Attorney General's Office that's responsible for prosecuting, and we have the Ministry of Justice that's responsible for trials and then sentencing through our prisons. And it's quite hard to join those up together to look at, if you like, the experience of a case from a victim's perspective or a suspect's perspective that it goes through. We tried to do a lot of that in my time as the DPP. I think we got better. But one of the things we didn't do was, for example, talk to the Department of Education and say, well, can you join in with this? Because when we are trying to turn people away from the moat, that is about educating young people. They need to know where the line is, where the moat comes, what they should not be crossing, but they also need, I hope it's not sort of pompous to say, some skills in life, some skills in behavior and conduct. And I mentioned rape, for example. The attitude of boys and young men to girls and women starts very early. And I would argue it starts from primary school age, definitely secondary school age. And if those attitudes towards the rights of women aren't bedded in young boys and men, you're going to see a number of things happen. You're going to see the toxic masculinity that's a real phenomenon in society now. And you're going to see appalling conduct towards girls who are not treated as equals. And that is going to end up in all sorts of offences, including violent sexual offences. Whereas if you can get people to understand that everyone has their rights and is entitled to be treated with respect, it is less likely, it's not going to rule it out, but it's less likely that you will find offensive conduct that grows and grows and becomes criminal. So I would say that what we need actually is more joined up thinking across the system, less living in our little bunkers or silos, come out of that, take an approach to crime that will be much more effective. It will involve some hard thinking, it will involve some expenditure, some money. And of course, it is not going to eradicate crime. You're never going to do away with the need for a national prosecuting authority. That's the Crown Prosecution Service. I was very proud to lead it. A lot of incredible people in there who do what has to be done on those hard edges where cases come to court. But those people, those thousands of prosecutors and all the support professions within the CPS are also brilliant at recognizing behavior. And when we go out into communities, and we have things called community accountability forums within the CPS, they listen to communities about behavior, about issues within those communities. And a lot of prosecutors, believe it or not, I think would be great spokespeople for trying to hold people back from the moat, show the consequences of crossing the water, and make it clear to people at a much younger age that they don't want to go there, really. Not in their interests, it's not in society's interests. And if we had that big conversation, I think we could work some improvement. But it's not for me to sort of sanction that conversation. It's probably even beyond you, Maria. But it takes real initiative from the top to change things and to change attitudes. And then we should see crime dropping. It's often said that the crime wave in this country is less than it used to be, and it was worse in the bad old days. As a prosecutor, take it from me, there's a huge amount of crime, and there are peaks and outbursts of particularly nasty crime that need real attention. We live in a safe country in comparison with many others in the world, but there's also a huge amount of crime, and we've got to focus on that and look at the criminal justice system not as something that we sort of put in the corner for people over there to deal with, but as a responsibility for the whole of society.
Yeah, you were making me think about a project I was involved with in New York, in the state of New York. on Long Island back in 2013, and it was an alternative to incarceration and a re-entry project funded by the district attorney, because of course the district attorney is an elected official, and so the more they can do to do crime prevention is going to help them in their elected position. And this started, it's a story worth telling actually. It started as an area where it was pretty much an open air drugs market, and the head of prosecutions went to the police and said, you know, we keep arresting people. We've been arresting people for 20 years, and every time we put someone in jail, someone else pops up and takes their place. So they constructed a project where they brought 16, they had video evidence on 16 drug dealers, and they gave them an amnesty for an evening to come to a community meeting and meet the community. And they said, if you turn up, we won't prosecute you on the way there or on the way back. And all 16 turned up, and the community said, and you know, clearly there was a lot of work before that meeting. Community said, we're claiming our streets back with or without you. We'd rather do it with you. And the prosecution said, so if you agree to exit gang life today, we're going to set up a project for you, which they did. I came in much later when the project was set up. But if you choose to go back to that world, we're going to come after you. We've got evidence. We will come after you. We will find you. So you've got this opportunity tonight. And actually, all 16 agreed. And only one person, I think 2 years later, only one person like relapsed and reverted and went to jail. And in fact, a couple were working for the prosecutor's office. And I got called in to do some conflict resolution work, because wherever you put people together, there's going to be conflict. But I saw amazing turnarounds. And in fact, actually, I was in Long Island this recently, a month ago, and I met three of the people that I worked with back then, who are still doing, amazing work, just like helping their communities, passing this stuff on. And one of the, which comes back to resources, one of the things that they asked people to do in their program was find 5 people who are not your friends, not your family, not the normal people you hang around with, 5 people to become your board of advisors. And so each person was tasked to find 5 people who would be like you, for example, or me, or whatever, that they would go to keep them on the straight and narrow, and to give that advice that wasn't based on you're my mate and look at who we hang around with. Absolutely amazing work.
Yeah, and that is a great example of conditional cautions going large. And I do think that, you know, everybody says, well, we have the oldest and best legal system. I'm very proud of the legal system in this country, actually. And if you compare it with other legal systems around the world, most other countries, jurisdictions, have a great deal of respect for the English system. In this country, people don't quite get that, but if you go abroad, you will see how well we do things. But we should be going to other countries. We should be looking, as you did on Long Island, at examples of best practice, better ways of doing this. We did some of that through the Times Commission report that I mentioned and looked at the US. And I think it's finding ways to shift gears here and to really make a difference. And it can be done. All I'd say, of course, is that, and I had some of the big district attorneys were colleagues and friends of mine when I was in office, because they're elected, the budgets that they have, and actually the funding at their disposal allows them to take a direct role in funding community outcomes. Please don't expect the CPS to do that. They are massively overstretched. When I joined the CPS, just to give you this perhaps final example, I found that I had 5,600 staff. To put that in proportions, from 2010 to 2018, when I joined, the headcount at the CPS went down 30%, and the annual operating budget went down 44%. So that sort of national adversity economically had a massive impact on our ability to do what we did. I spent 5 years trying to build that through trying to persuade government, the Treasury, and others to put more money in. And by the time I left, the headcount, the number of staff was almost exactly 8,000, and the annual operating budget had gone up by 50%. I hope it stays there because even at those levels, with this overcrowded system that we've been talking about, the prosecutors are working at top gear. And I used to say that you've been in fifth gear for a year, try and keep going for another year. But it's exhausting, and you have good people who are working flat out. What they can't do is resolve these huge societal issues. So that involves more funding, joined up thinking, and trying to find creative solutions. But you've been a pivotal part of one of those in another country, and I'm sure that we could do that if there was a will. And the outcome would be what we all want, which is a reduction in crime from the start, whether you're talking about drug crime or very low level street crime, violent or non-violent. We don't want people to start because once people start, it off does not always, but often happens that they'll continue. And if you can turn them back, then that leads to less problems for all, including those people themselves further down the line. So it's not easy, but I think we should be having these big conversations because we need the change.
Oh, yeah. I mean, I've got so many ideas of things that are all entirely possible. And I mean, at the moment, I'm embarking on, we go into prisons and we train groups of prisoners to become mediators, facilitators, to help people who are struggling because they're in prison. They're a great resource. Just because someone goes to prison and they've done something terrible, they don't lose all of their intelligence and their internal resource. So let's put that to really good use. And I have a vision of taking some lifers through this, and then when they come out of prison through the gate into jobs on the housing estates, doing that work with the young people before the young people get involved. Because as I said, once they've got involved, it's very hard to get out. It's very tangled.
Well, good luck, Maria. And there are good people, even though they may have served long prison sentences, who really deliver back to their communities. And of course, they have huge credibility because of what they've been through. So they are absolutely part of the solution. We shouldn't look at them as a lifelong part of the problem. So that's, one segment of a big discussion about how to improve things. And, let's come back, I suppose, at the end to this Court Modernization Bill. It is a good thing that we have a government that's looking at this and has modernization in mind. It's not a bad thing. The reason we are where we are is because the system's been starved for too long. So we want a government that's prepared to look at this. It's just the way they do it and their selection of changes and how much money they're going to put behind it that is the really important thing here. And I'm sure that, the leaders of the legal professions would say, we want positive change. We'd like to work with you, the government, to create that change. But we don't want crude measures that are going to impinge on people's rights, like jury trial, if they don't make much difference to the backlog that we're all rightly obsessed with. So that's where the detail of the conversation needs to come from. And it'll be very interesting to watch. It's no longer my job, but I'm watching with real interest, as we all should.
And then, of course, you have the further problem, which is, you can have a great initiative and people can get behind it, but things take so long that then you get a change of government or a change of minister, and then it's like a game of snakes and ladders. I mean, I think the country is incredibly fortunate to have James Timpson as a prisons minister, but he's not going to be there forever.
Yeah.
Um,
I completely agree with you. And I'm not being funny. I almost lost count in my 5 years as DPP with the number of prime ministers, the number of Lord Chancellors, the number of attorney generals, the number of home secretaries. There were so many of them. I think in terms of Lord Chancellors or Secretaries of State for Justice, there were six, and that's if you don't count one who was appointed twice. So that's more than one a year. And if you have no continuity, then you can't make a difference. Bring in a real subject matter specialist, and James Timpson is one of those. He's proved that over decades. That is the sort of person, leave politics and the color of the party to one side. That is the sort of person who, if they're given a chance, will make a positive change. And so, to that extent, we need continuity. We don't need constant chopping and changing.
Wow, yeah. Well, this has been a fascinating conversation, and I think we're coming to a natural end of, we could open up 1,000 subjects, I expect. We could do a whole series. Um, but I do have a final question for you, a sort of surprise question, if you like. And that is, if you were to be given the keys to the Ministry of Justice and you could make one change immediately, what change would you make?
Well, that's a really good question. I think what I'd say is I'm going back to where I come from. Where I come from is a lawyer. Never mind whether I prosecute or defend. I'm interested in delivering justice. You're a cog in that wheel. And you only deliver that through the work of a lot of people. But in particular, the focus is on the courts and the legal profession and the judiciary and the buildings to conduct those trials. We had an organization which had sole responsibility for that, and it was called the Lord Chancellor's Department. And that was disbanded and then rebuilt into what we now call the Ministry of Justice. And the problem with that, this might be controversial, but this is my view, is that where you give a single budget to a government department, but that budget has to stretch across all sorts of different areas, it's always going to be a question of choice as to who gets the money. And what's happened in justice terms, I think, is that the prisons, the prison estate, the physical prisons, and the numbers in prison have become such a problem that they are effectively sucking money out of the budget that the Ministry of Justice has. And that means that money's not available for that sharp end, namely the courts, the judiciary, and the lawyers. And given that that same budget also has to support the probation system, you can see you've got at least a three-way tug of war. So if I was asked, you know, what kind of change, I wouldn't necessarily recreate a Lord Chancellor's department. It's sort of old-fashioned language. I'm not fussed about that. But I would want a dedicated organization and a dedicated budget to do what is needed to make sure that we have lawyers tomorrow. We have funding for those lawyers to act for people who don't have money of their own, but who need a guiding hand through a complicated criminal justice system. And we have money for the judges of tomorrow and the courts of tomorrow. And if that could be done as a single funding stream, which we all recognized is so necessary, that is the change I'd make. There are a lot of other questions, such as, okay, where would prisons go? Who'd look after that? Where would probation go? I'm not saying they're not important, but I have witnessed firsthand the erosion of our courts, the leaky roofs, the lifts that don't work, the lawyers who've been on the same rate of pay for 20 years when they turn up to defend somebody who really needs that defense. And if you don't invest, then the whole system degrades. So that's the change I'd make. And you can call that special pleading because I'm a lawyer. I don't care what you call it. I think unless we give support where it's really needed, we're not going to dig ourselves out of this hole. So that's the best answer I can give.
Yeah, it's a sort of quite a technical answer. It's not so obvious, but it makes total sense because, for people like me who are not working within the system, we don't see those things, but you can see when it collapses.
Exactly.
And And then I think just to round off, you know, having done some work in America and a few other places and looked at the way things run, I do think we do fundamentally have a fair system where people actually do really care. There is something about it, even in its collapsed state, that is a lot better than other countries, and I think we ought to be grateful for that.
I would go further. I would say that we have the best legal system in the world.
Mm.
And there are so many examples you could give of that. But if you just go back to the spring and summer of 2020 and look at how, even with all its problems, the justice system in England and Wales got back on its feet as we were coming out of that first lockdown. And then you compare that with other legal systems around the world, we were almost the first to do it. I don't think any credit is given for that. And you only understand that when you go around the world, as I did, because we had an international remit, money, evidence, and people don't necessarily sort of stay put in London waiting to be caught. You have to go and get them. So we had a network of prosecutors out there, and I would travel and see them. And the English legal system not only has been the foundation for so many legal systems around the world, it is still held up as the best that there is. But, and this is important, that won't continue to be the case unless we have proper investment to protect the system that we all cherish. And, it gives me great anxiety that a system under so much pressure can only go on for so long before people crack. And to be very straightforward about it, before lawyers say to themselves, why am I dealing with cases? I might make more money by doing something else. These people are not in it to become rich. They're doing it because they believe in the fundamentals of English justice and they're prepared to work for far less money than they would in other areas. And that is where the support is needed. Otherwise, we'll find that the system is eroded and we can't get it back to where it was. And by then, it'll be too late.
Yeah, what a timely observation. And thank you. This has been an absolute delight, and I've been really touched by your thoughtfulness and your care. And 40 years you've been doing this work. What a service! What an amazing service. Thank you.
Thank you, Mira. That's very kind. But it's also a privilege. And studying law 40 years ago, if you said to me you can have half of the things and half of the great opportunities I'd have had, I'd have taken it. And I've been extremely lucky to have more than that. So it's been a privilege. Still is.
Thank you.